Look, let's just move on to another topic. And boy, a lot of people have watched my interview with Posey Parker yesterday. Of course, none of the New Zealand media which uphold democracy could be bothered speaking to Posey Parker. And not so much coverage of the, non-sentencing of a young man from Gisborne who pled guilty to common assault, and that is hitting a 71-year-old woman at the protest. And look, I just want to start this whole thing by saying sometimes people are very, very decent. And Judith, who's been on this program before, had a bone broken in her face and horrible injuries after being struck 3 times by this young guy. But yesterday she came out, and Posey Parker, as I mentioned at the start of my interview yesterday, and I asked her not to name him, had named this guy who got permanent name suppression and discharged without conviction by Judge Glubb. This woman, the woman who was the victim of this assault, and you don't dress it up, she was the victim. She was beaten by this young guy, and it was an appalling crime, which he pled guilty to. But she said, and she asked people not to name him further and not to pile on him. She said Posey Parker's naming of him in another jurisdiction, in another country, had clearly caused quite a lot of trauma and trouble for his family. And in many ways, she felt now that the punishment he has received and his family has received is sufficient to make her feel she has justice. And in what I consider a very noble act, Judith said, just leave him alone, let it be now. And law aside, I think that was a very decent thing for her to do. And if you're one of those who is baying for blood or to put someone in the stocks, I think you should listen to the victim in this crime. She has more right than anyone else to be outraged, and she's saying, well, in a strange old way, justice has been done. I think it's also important that we understand how this man was discharged without conviction after pleading guilty and why he had name suppression. And I think the best person to explain that to is when I get confused about law stuff, he is the guy I ring often off the record to get some clarification in my head. Wellington lawyer, and I guess our go-to guy at the platform here for law stuff, Graeme Edgeler. Graeme, welcome to the platform again. Nice to have you back with us. Oh, I've got to push your button so I can hear you, don't I? There we go. We've got you now, Graeme. How are you?
I'm good. Thank you for having me on.
All right. Look, Graeme, I just think when something like this happens, you know, social media goes nuts and we often lose track of what the law actually says. And I guess the impression I've seen from many people online is that somehow this Judge Glubb, bent over backwards to bend the rules for this particular young man. Firstly, is that the case, or was he acting in accordance with generally accepted practice and convention in our court system?
I think I'll probably draw a distinction between the discharge without conviction and the name suppression.
Yep.
I think the discharge without conviction is probably the one that is more obvious. You know, sort of probably, you know, like you could disagree, but you know, that I think was very much in line with sort of
and what are
approach.
the provisions? Let's go there first then. What are the provisions and the circumstances under which anyone can expect discharge with conviction? Can I start by asking, do they have to plead guilty first to be eligible for it?
No, you don't have to plead guilty. Most of the time that would be the case, though. It would be a guilty plea. And it does not have to be a finding of guilty after a hearing and a trial. You can apply at that point for a discharge without conviction, but it's harder. So, I mean, one of the things that the judge will look at is, you know, the level of remorse, things like that. If you have pleaded guilty, that is something that will make it easier for a judge to look and say, okay, well, the consequences of entering a conviction for you are more serious than they need to be, given all the circumstances, given the person you are, given what was involved in the offending, And if that's sort of the order
and
things
do you
that happen,
ask for discharge without conviction, or does the court just grant it if it feels like it?
you would almost, yes, you would have to ask. Yeah, so that will be something you come up for sentencing, and your lawyer, almost certainly you'll have a lawyer. If you don't, you'll find it very difficult.
You're an
probably,
idiot.
I would think.
Yeah.
Your lawyer will your lawyer will make an application and say to the judge, there should be a discharge without conviction.
Okay. And that is based on what might be the disproportionate consequences of a conviction, right?
Yes.
Okay. Does it also look at the specific details of perhaps how much publicity a case has got, and if in that the specific case of that crime or those circumstances, there would be a disproportionate result? And I ask this in relation to this case, Graeme, because I imagine someone might say, common assault, if it wasn't a high-profile case, they wouldn't be at risk of all sorts of things that have flown in this instance.
I mean, potentially that could, what has happened to you already? Like, one of the things that the judge will look at is, if I was to convict and sentence you, what would the sentence be?
Yeah.
And so, it's the sentence in this case, first offence is a 20-year-old, obviously, a serious impact on the victim, but a relatively minor offence. The maximum penalty. I've never been 100% sure exactly what charge they faced.
It was common assault.
But common assault, which, depending which one, like there's two of those, is a maximum of a year in prison.
Okay, so it's less than, and I hate to draw the comparison.
So that's never going to happen for a first-time offence.
It's less than the 7-year sentence that Garriman would face for shoplifting.
The maximum, and
maximum, yeah.
Garriman does not face that.
Yeah.
When you're being sentenced, the maximum with and it's a very weird experience. A first-time offender is not going to get the maximum sentence. Like, I can think of one case where that's happened, and that was the Christchurch terrorist.
Yeah. Yeah.
First conviction in New Zealand. I don't know if he had any Australia or anything like that.
Yeah.
He got the maximum penalty. No one else is going to. Not for a first offence, not for a minor offence.
Yeah.
And so, not when you plead guilty. Not when you're 20. And so prison was never going to happen. So even if one of the things the judge will look at, okay, what if I was to sentence you, and it might be community work would be a possibility for something like this. And so one of the things that is taken into account is, the types of things that a judge would do if they were to sentence you, if you've done those already. So, it might be a fine. So one of the things that would be quite common is, well, I'd fine you, but you've made a $1,000 donation to a charity.
Yeah.
Okay, well, okay, so you've lost out on the money.
Yeah.
Or in this particular case, the suggestion I think I read from the sort of news was there had been a sort of a payment to a charity, and this person had also done some community work.
Yeah.
In the time since, it's like, okay, well, I'd have imposed that, but if I was to impose community work of 100 hours, well, you've already done over 100 hours community work since the offending. So okay, well. That's another factor that the judge will take into account.
All right.
You've already the types of things that I would impose a penalty on you if I was to actually convict and give
you've already
sentence,
done, or you've already paid that price. I get you.
And
I get
if it was a much more serious charge, then that wouldn't work. But so well, no, but yeah.
Okay,
so
I get you. All right, and so you're saying in this case, when you look at it, and I'm not asking you to sign this in blood or anything, your general observation would be that under the circumstances, let's put aside the media interest in this case, under the circumstances, this is not a surprising, particularly liberal or out-of-whack decision to discharge without conviction.
Correct.
Okay.
It's not so, if it had been, slightly more or something like that wouldn't be all surprising either.
Yeah.
One of the things I think that is important as to what the actual result was here, what the charge was.